This afternoon, the business or the procedure in the hearing and determination continues. The Speaker of the Senate, Honorable Amason Jeffa King, is in the chamber to resume this debate. Allow me to hand you over to the proceedings.
Na tuombe. Mwenyezi Mungu, twakusihi tutazame kwa neema nyingi na baraka sisi watumishi wako ambao umeridhika kutuita kwa nyadhifa za uongozi katika jamhuri hii yetu. Twakuomba tuwajalie tuyatende na kufikia mambo yote yatakayofikishwa mbele yetu kwa njia ya haki na uaminifu, ili kustawisha amani, ufanisi na heri ya nchi yetu na wale ambao haja zao umezikabidhi mikononi mwetu. Amen. So, Clerk, do you have quorum? We do have quorum. You may proceed to call the first order for the afternoon.
Order number 1, communication from the chair.
Now, honorable senators, ladies and gentlemen, as you will recall, at the commencement of the hearing of the proposed removal from office by impeachment of Honorable Amos Kimwoni Nyaribo, the Governor of Nyamira County, earlier today, Wednesday, 3rd of December 2025, Counsel for the Governor raised a preliminary objection to the hearing of the proposed removal from office by impeachment of Honorable Amos Kimwoni Nyaribo on the following grounds: that the impeachment motion dated 11th of November 2025 failed to attain the constitutional and statutory threshold, and that therefore the purported resolution for removal of the governor by way of impeachment was invalid and incompetent, as it failed to meet the mandatory threshold under Article 181 of the Constitution and Section 33 of the County Governments Act, and B, that the concept of proxy voting was alien, illegal, and null and void, and the attempt to explain the discrepancy through proxy voting was legally untenable and compounds the illegality of the proceedings premised on acts of fraud, forgery, and misrepresentation. Now, honorable senators, in urging the Senate to find that the threshold of 2/3 of all members of the County Assembly in support of the impeachment motion was not achieved, Counsel Elias Mutuma for the Governor stated that the County Assembly of Nyamira comprises 35 members, and that therefore the requisite 2/3 majority for a valid impeachment resolution was 24 members of the County Assembly. Council further submitted that the official record of the sitting of the County Assembly held on 25th of November 2025 confirmed that only 19 members were physically present in the Assembly chamber. Council stated that despite this, the Assembly recorded 23 votes in favor of the motion, and that this was numerically impossible, and that to him, this demonstrated that improper and fraudulent voting had occurred. Now, Counsel for the Governor submitted that the phrase, all the members of the County Assembly in Section 33(2) of the County Governments Act is not ambiguous and refers to the total composition of the County Assembly as established under Article 177 of the Constitution and as gazetted by the Independent Electoral and Boundaries Commission after the 2022 general elections. Now, Council contended that as a membership of the Nyamira County Assembly is 35 members, and as 2/3 of 35 is 23.33, this can only be rounded off to 24 members. Now, Council further submitted that the County Assembly's argument that the 3 vacancies in the Assembly reduce all the members, end quote, from 35 to 32 was legally flawed and absurd. Council therefore urged that for these reasons, the impeachment proceedings before the Senate could not proceed and required to be terminated at the preliminary stage. Now, Council for the County Assembly took a different view on this matter. The thrust of the argument in response to the first preliminary issue was that the Independent Electoral and Boundaries Commission, IEBC, in Gazette number 9956 of 2022, published on 24th August 2022, set out the names of the elected members of the Nyamira County Assembly, and further that this was not the limit or absolute number of members who were required to sit in the Assembly at any given time. Council further noted that when the Constitution and the County Governments Act imposed the requirement of 2/3, this could only refer to 2/3 of the members present at any particular time. According to the Council, an alternative interpretation would mean that no activity could go on should there be a vacancy or a challenge in filling the vacancy, and further, that any business that has been transacted by the County Assembly of Nyamira on the basis of the members of the County Assembly of Nyamira at the time will be null and void. Council further stated that this issue is a question of fact that ought to be determined through the examination of evidence during hearing. On the second limb, on the second limb of the preliminary objection relating to voting by proxy by the 4 members of the County Assembly, Counsel for the Governor stated that this was alien to the County Assembly procedures, illegal and null and void. Counsel further stated that no authority was granted by any member to vote on the behalf by proxy, and that the 4 members of the County Assembly in whose names proxy votes were recorded had provided sworn statements confirming that they were neither present in the Assembly nor did they issue an authority written or otherwise for any members to vote on the behalf. In this regard, Counsel for the Governor referred to the Standing Order 67 of the Nyamira County Assembly Standing Orders, which requires the decision of the Assembly be made by members present and voting. Counsel argued that the act of proxy voting was expressly prohibited and was a nullity as it contravened Standing Order 67 of the Nyamira County Standing Orders and the principles of representative democracy. It was Council's case that the unauthorized casting of votes in the names of absent members without the authority constituted fraudulent misrepresentation, forgery, and impersonation, further vitiating the entire process. As such, the Governor takes the view that the maximum number of voting MCAs would have been 19 MCAs. The Governor concludes that the required statutory threshold of 24 members of the County Assembly to support the motion was not achieved. In response, Counsel for the County Assembly stated that the delegation of voting by proxy was carried out in a right manner, and further that the proxy letters were available as evidence of the said delegation. Now, in support of this submission, Counsel referred to the case of Mukisa Biscuit Manufacturing Company Limited versus West End Distributors 1969 EA, page 696, which set out the threshold for a preliminary objection. In particular, Counsel stated that the issues raised and in question, that is the number of persons who voted, was a contested fact that ought not to be argued at the preliminary stage. He further stated that although the Governor's Council had indicated that there was evidence of affidavits sworn by 4 members of the County Assembly, averring that they did not delegate such authority, the County Assembly would, at the hearing, provide evidence of mobile telephone and email communication to counter this allegation. It was therefore not possible for the Senate to make a determination on the matter at the preliminary stage without hearing evidence on the matter. Now, Counsel further argued that although proxy voting was not expressly provided for in the standing orders, the Speaker of the Nyamira County Assembly had exercised the discretion provided for Standing Order 1 of the Nyamira County Assembly Standing Orders to allow for the proxy voting. He further stated that although the standing orders were silent in expressly providing for proxy voting, this did not bar the use of proxy voting in the Assembly. Now, Honorable Senators, following the oral submissions on the preliminary objection and the responses, Senator Edwin Sifuna, Senator Emma Komboa, and Senator Boni Halwale sought various clarifications from Council, including on the relationship between provision of the Constitution on vacation of office by members of parliament or county assemblies vis-a-vis the provisions of law as that set out threshold for voting on a matter, at what point the membership of a county assembly is determined after election, or whether this is a moving target, and whether it will not be prudent to give the county assembly the opportunity to adduce evidence on the matters raised in the preliminary objection in the main hearing. Subsequently, the respective council gave the responses to the questions and clarifications sought by honorable senators. Arising from the preliminary issues canvassed, the following are the issues that require determination by the Senate. 1, whether the preliminary objection raised qualifies as a preliminary objection, properly so called, and whether therefore its determination must precede the further progress of the current impeachment process. And 2, if the answer to the first issue is in the affirmative, then whether the 2/3 threshold required for voting on the impeachment motion of the county assembly was met. Now, honorable senators, I shall commence with the first question, which is whether the preliminary objection raised qualifies as a preliminary objection properly so called, and whether therefore its determination must precede the further progress of the current impeachment process. As you will recall, the Senate has previously been confronted with this question in previous impeachment proceedings. The question of what constitutes a preliminary objection was well set out in the leading case of Mukisa Biscuit Manufacturing Company Limited versus West End Distributors. And this is what, in that matter, the court held. A preliminary objection consists of a point of law which has been pleaded or which arises by clear implication out of the pleadings, and which, if argued as a preliminary point, may dispose of the suit. Examples are on the objection to the jurisdiction of the court, or a plea of the limitation or submission that the parties are bound by contract giving rise to the suit to refer the dispute to arbitration. A preliminary objection raises a pure point of law, which is argued on the assumption that all facts pleaded by the other side are correct. It cannot be raised if any fact has to be ascertained, or if what is sought is the exercise of judicial discretion. Now, honorable senators, in light of this similar decision, it is now well settled and established in our practice that a preliminary objection does not require evidence to be adduced as proof of its existence. It is limited to points of law and cannot be raised if a fact has to be ascertained by the use of evidence to be adduced. Reference has been variously made by counsel for the governor and counsel for the county assembly to the jurisprudence that has been laid down by this house in the two Kericho impeachment matters, now commonly referred to as Kericho 1 and Kericho 2, in which the Senate arrived at different conclusions on the nature of preliminary objection and the appropriate place at which to make a determination. In fact, there was no contradiction in the determinations made by this House in Kericho 1 and Kericho 2. In Kericho 1, the Senate determined that a classical preliminary objection was one which is purely a matter of law and which required no evidence to be adduced for its determination. In that case, it was not in contention that the number of county assembly members who had voted in support of the impeachment motion was 31. It was also not in contention that the total number of Kericho County Assembly members was 47. The only question was whether 31 members constituted the 2/3 threshold as required by law. In Kericho 2, on the other hand, the question was whether some of the county assembly members alleged to have voted in support of the motion did actually vote. This was a matter requiring evidence to be adduced, including the examination and cross-examination of the said county assembly members, and accordingly, this was not a matter that could be determined at a preliminary level without hearing the evidence. Kericho 2 was therefore ruled to belong to the second category of preliminary objection that can only be reasonably subsumed in the full hearing, but for which a determination by the Senate would have to be made at the end before the proceedings to vote on the charges. The question, therefore, is whether the current preliminary objection belongs to the jurisprudence of Kericho 1 or Kericho 2. Now, honorable senators, in the current impeachment proceedings, It is not in contention that there were 19 members in the County Assembly of Nyamira present and voting at the time of impeachment. Secondly, although there is contestation about the validity of the votes purportedly cast by proxy by another 4 members, there is no contestation that the total number of members who voted did not exceed 23 members. The County Assembly, by its own admission, has submitted a list of 23 members as having supported the impeachment. The governor's side, on the other hand, object to this impeachment on the basis that the correct threshold should have been 24 members rather than any lesser number. What is in contention, therefore, is whether the threshold of members required to have voted in the matter is 24 or 23 or lesser number. What is additionally in contention is whether in reckoning the 2/3 threshold, the number of members of the County Assembly is to be applied as 35 or 32. The legal question in contention is whether the number of legislators of the County Assembly remains fixed and unaffected by any vacancies for the purposes of reckoning thresholds, or whether, as Councillor Carter Keegan for the County Assembly argues, it is a moving target that cannot be reckoned in advance and depends on the membership of the Assembly at a particular time having subtracted any vacancies existing. Now, honorable senators will appreciate that this is a constitutional and legal questions of the most fundamental ramifications. The decision on which reverberate far and wide and well beyond Nyamira County Assembly, and possibly including this chamber, where at various times and for various reasons we have had vacancies. The decision the Senate takes on this legal question will no doubt bind us going forward in the manner in which we reckon delegations for purposes of voting when there are vacancies in the Senate. From this perspective, it is clear to me that even though a number of matters of fact were raised by the County Assembly in their preliminary objections and fundamental legal questions of threshold, and whether the correct number of delegations that were required to impeach the governor of Nyamira County at the time of the impeachment was undertaken was 24 or 23 or any lesser number is a pure question of law whose determination by the Senate is necessary before these proceedings can continue. This is a preliminary objection of Kericho 1 typology. Honorable Senators, this legal question goes to the substratum of the impeachment proceedings and has the prospect of terminating the proceedings at this point. Accordingly, and as I've guided from this chair before, this kind of preliminary objection raised by the governor requires to be determined by a vote of the Senate, which is the trial court in the impeachment matters. It also obviates the need to answer the second question on whether the threshold was met. The threshold was met, as this is what will be the subject of the vote. Now, the manner of proceedings to this vote will be a motion, moved in the usual manner after notice of motion has been given. Debate will ensue in the usual manner, and the vote will be taken upon the conclusion of debate. To this end, honorable senators, I have directed the clerk of the Senate to prepare and circulate a supplementary order paper containing a notice of motion, and the motion limited to the preliminary objection on the threshold that was required for this impeachment. Now, honorable senators, the decision on the proposed removal from office by impeachment of the county governor and any consequential or incidental decision thereto are matters concerning counties, as has been previously ruled in all impeachment processes undertaken by the Senate. These decisions are made by the Senate by vote, by county delegations. Accordingly, the preliminary issue will be upheld only if it's supported by votes of at least 24 delegations. If the preliminary issue is upheld, this impeachment shall terminate forthwith. If, however, the preliminary objection issue is negated, the Senate will proceed to the main hearing of the impeachment proceedings. It is so ordered. Thank you, honorable senators. So, honorable senators, you'll be provided with the supplementary order paper that is going to guide us in the proceedings for the afternoon.